19-0508 VACC versus Chicago title. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for rebuttal, but you'll have to manage your own time. We have a clock at the bottom of the screen. I don't know if you can see it, but that's roughly how we'll keep track of the time. We're recording the argument both in audio and video, so when it's your turn, please identify yourself and your client, so when we go back to review the recording, we can keep everybody straight. The recording will be on YouTube in a couple of days, and you can see how well you did. We've read the briefs and conference the case. We understand the facts and the issues, so when you begin, just launch right into what you would like for us to know. Counsel, you may begin.
Great, thank you, Your Honor. Good morning, may it please the court. My name is Corey Broadbent. I'm with Cassandra Ayers from our office at Buse, Gilbert, McGroder. We're here on behalf of Plaintiff Appellant VHCC LLC. I would like to reserve 5 minutes for rebuttal, if I could. I'll start my clock. This case is a prime example of when a trial court errs in granting summary judgment, despite a myriad of disputed factual issues, despite a myriad of disputed issues about the intent of the parties, about the predicate and the underlying facts that gave rise to the contract at issue, about the representations by and between the parties that gave rise to the agreement, and the interpretation and enforcement of those agreements based on the fact and the law. I appreciate that the court has read the briefs. I will try not to belabor too many of the factual issues. However, considering this is, at least from our perspective, a genuine issue of material fact that should have precluded summary judgment, I want to highlight a few of those factual issues just for purposes of the record. As we pointed out in our brief, obviously this case concerns a development known as the Villages Country Club, which VACC contracted to purchase. That purchase agreement was accepted by Chicago Title Agency. It defined what VACC was buying, but more importantly, it defined what CTA and ultimately CTIC, the appellees, were going to insure. And it defined those as 369 finished and partially finished townhome lots, including 6 completed and 18 partially completed lots. Those references to both lots and units and the identification of them in those 369 individual units is critically important. One of the arguments that has been raised by appellees is that ultimately what they insured was a single parcel that was bounded by the meets and bounds as defined in the plat. That argument is belied and contradicted by the actual language of the purchase agreement, by the title commitment, and ultimately the title policy. Ultimately, appellees agreed to be bound by the title commitment. They agreed to insure in fee simple these 369 individual lots. It also has tracks A through J, and it identifies in the purchase agreement and title commitment these lots and units by 369 individual assessor parcel numbers. Again,
Counsel, what's your view of the exception in Schedule B for that it's subject to conditions of the plat?
It's a great question, Your Honor. Well, it's subject to, I think the language says, easements, covenants, conditions, and restrictions as set forth on the plat. Would argue that nowhere in that plat does it list covenants, conditions, or restrictions as set forth on the plat that limit it to a single parcel or to underlying leased product. Ultimately, the way the parcel is drafted led a reasonable buyer, my client, to believe that it had the right to sell those units in fee simple to subsequent purchasers. Nowhere in that plat, or at least as condition 6, does it set forth on the plat a restriction that would preclude that from being the ability. More importantly, my client, ultimately VACC, hired appellees to produce a title commitment, to do a title search, and to apprise them of any such restrictions. None of those were ever forwarded or disclosed to VACC. Ultimately, what they had was a plat which when they contacted and coordinated with the seller communicated to them that ultimately the plat was designed that with the extinguishment of a ground lease, it would automatically convert over into a fee simple product. That was the way the seller originally designed it and how it was sold to the client and how ultimately it was insured by Chicago Title.
But it was sold with the lease, at least the lease provision was in there at the time your client purchased it, right?
Well,
sorry, go ahead. Presumably your client could have turned around and sold it with that same restriction to someone else with the setup to lease the property and with buildings on leased land.
But ultimately that was not the intent of VACC as expressed to appellees of what they intended to do with the property. They had told appellees, the city, seller of their intended use of the property. The sellers had said, all you have to do is get rid of the ground lease. But importantly, when they communicated with appellees originally had some lease language in that title policy. And VACC very specifically, there's an email in our briefs where they say to appellees, you have to remove the ground lease. There will be no ground lease. It has to be extinguished at closing. As advised by VACC repeatedly in its depositions, it would not have purchased the property if that ground lease couldn't be extinguished and converting the property to a fee simple product, which appellees were aware of.
But it was ultimately done. Your client was able to do that, working with the city to remove that provision.
Ultimately, it was done. But I guess that gets us to the point, doesn't it? That ultimately the fact that it was corrected and cured required certain damages and incurred or inflicted certain damages on my client. If appellees had performed their duties and had done what they were instructed to do and what they'd committed to do, my client would have had to replat the property and go through all those expenses. Ultimately, that's the issue, is that my client was damaged by that. The fact that it could be cured simply gives rise to a measure of damages, not that there are no damages.
Are you relying on the reasonable expectations doctrine, or are you saying the specific contract, notwithstanding Schedule B6, that it was contemplated under the title policy?
Well, I think it's both, Your Honor. I think it was both contemplated by the original title policy. As we argued in our brief, we think that Schedule B6 is contradicted by other language and superseded or insured over by different provisions of the title policy. But I think it was also in the reasonable expectations doctrine, what was communicated by and between the parties, what we represented to them, what they represented to us, what they knew our intended use of the property was, what they led us to believe we could do.
Which specific provisions do you think then trump a Schedule B6? Of
the actual title policy? Ultimately, the covered risks, as articulated by our expert, what he's talking about in that exception B6 talks about intended use. And as opined by Mr. Caldwell, ultimately what that does, though, is only talks about what an intended use can be, not necessarily what the intended use will be. And you look at the covered risks include on 1, 2, and 5 risks that are covered for us, and that ultimately that exclusion should not be permitted to supersede what a covered risk covers.
Do you disagree with the general proposition that reasonable expectations are inapplicable unless you have an adhesion contract? Or are you suggesting that this is an adhesion contract and that that reasonable expectations trump the exclusion?
Sure. I think that I wouldn't use the term adhesion contracts. I don't think that's what the Supreme Court has said in a couple of different cases, and specifically in Averitt. It's not that it has to be a contract of adhesion, but it's whether or not they are specifically negotiated, whether or not they are boilerplate terms. And I think here, that's exactly what we have, is they're boilerplate terms offered on a take it or leave it basis.
But doesn't that go to, where is it? Why would we conclude that it's a take it or leave it basis when other provisions were in fact negotiated? Doesn't that suggest that it's something other than a take it or leave it contract offered by the title company?
Well, I think that belies the fact that ultimately those provisions weren't specifically negotiated. We requested that provisions regarding the lease be removed, and they were removed. But other provisions of the lease were not, of the title policy were not negotiated on a line-by-line basis. It was, please delete these two because, as you know, we're not going to have a ground lease. but that was the sum and substance of any modifications to the title policy. We weren't allowed to come in and say, we'll take this and take that. Even the endorsements that we specifically requested are form endorsements. The title policy is a form policy. They took out the two provisions that they knew weren't going to apply because the ground lease was supposed to go away. But I would disagree that this was specifically negotiated. This was a contract, a form contract that they use. It has written across the bottom of the title policy repeatedly, form X, Y, and Z, that is offered. Hey, this is our title policy. You'd like title insurance from us? Here it is. But
was there any evidence that you tried to make changes to that, what you're calling a form contract, that you were denied making those changes because they said it was take it or leave it?
I don't believe there's any evidence, Your Honor, of any specific provisions that we attempted to alter. We requested the two lease provisions be removed,
right?
Because we believe that those were not applicable. But ultimately, we thought that what we were buying covered us, and just out of an abundance of caution, our client purchased additional endorsements that would cover those things that we thought, we were wanting to do with the property. But as far as a deletion of line that was rejected or accepted, no.
But you were not required to enter into the contract. You chose to do that.
Agreed. We chose to do it believing that the contract and that title policy did exactly what we were purchasing, which was to protect our ability to buy and sell those 369 individual units. If we had thought that it did not do that, we would never have obviously entered into that agreement.
What did you think was the meaning of the of B6, where it said excludes defects arising under the plat?
We believe that the plat as existed, again, according to conversations with the seller and with the appellees, that once the ground lease was gone, that plat converted over to a fee simple product. That's what the city told us, that's what the seller told us, that's what we believed it to do. And in fact, we did that 19 times after we closed, in fact, sold units in fee simple. So we never believed that B6, any language in the plat, would be restrictive on us in that way. Specifically, there was numerous testimony from mostly my clients, but from lots of other folks as well, that said we never would have closed if that ground lease was there. The ground lease had to go away in order for us to do what we were doing, and that's what we hired appellees to do. Okay, I guess I'll move on, just kind of hit a couple different topics. I think the court has highlighted a couple key points. We can talk about reasonable expectations in a minute. But I think if we get back to what the intent of the parties was, that's what this contract was designed to do. I recognize that the court obviously has some concerns about B6, but if we look at the contract in its totality and the circumstances and facts leading up to its execution, what we requested, what they told us we were selling, or what they were selling us, what we purchased, and importantly, what the endorsements were designed to do was to permit us to sell in fee simple 369 lots in a properly platted subdivision. Turns out none of that was true. More concerningly, we thought we were buying all of the land, as DHI subsequently discovered. Portions of the land hadn't even been conveyed to us. There were large gaps, strips, and gores that were not conveyed to us that left us without a totality of the property we thought we had purchased. Again, those were things that were insured over via endorsements. The subdivision endorsement was designed to be a properly created subdivision. If in fact Schedule B6 applied and this plat didn't exist, that subdivision endorsement would have been a nullity. If the entirety of the property had been conveyed, a contiguity endorsement would have been unnecessary. But that endorsement comes into play because not all of it was conveyed. That same as survey endorsement. The endorsement designed to ensure that if they went out and resurveyed the property, it would be reflective of what the plat is. As found by
insure against someone else having a parcel in the middle, or someone else having a claim on the property. You're saying that it also ensures just a specific use intended by your client.
I'm sorry, Your Honor, which endorsement?
The contiguous land provision.
No, the contiguous or the contiguity endorsement is designed to make sure there's no gaps or strips. I mean, obviously it would ensure and protect against somebody else having a claim, but in fact, that's what existed here. Because that property, no one else asserted a claim, but because that land had not been in fact been conveyed to VACC, it remained with the seller. To the extent Casa Encanta, the prior owner, had wanted to assert a claim, it could have, but it was designed to make sure that our land was contiguous along its common borders. And in fact, that didn't occur. As discovered by DHI, it hadn't been, in fact, ever conveyed to VACC and left us with the inability to cross certain portions of our land, to develop it, to do lots of things that contiguity endorsement was designed to address.
You're saying the seller would have had a legitimate claim against your client to keep portions of the property that it wasn't completely sold?
According to DHI, D.R. Horton's title agency, according to the city, according to our expert, that's exactly what happened. That property remained with the seller, with Casa Encanta. Casa Encanta could have come and said, hey, by the way, this is still my land. I'm not going to let you do X, Y, and Z. Now, Casa Encanta wanted to sell the entirety of the property to us, and that ultimately was resolved, by an assignment or a quitclaim deed from them to us. But the fact that it had to happen is demonstrative of the fact that the title commitment, the title search, and ultimately the title policy was defective and flawed, and required appellees to be responsible for damages to cure those defects.
Counsel, you're appealing this summary judgment not only against the title company, but against the escrow agent. I'm not really sure why you're doing that, since the party that you're dealing with is the title company, really.
Well, it's a valid question. I'll concede it's a valid question. I think that the reason why they are included is for a couple different reasons. As we put in our moving papers, the title policy was unclear in that it listed the insurer as Chicago Title Agency. So there was a bit of a conflict in the language of the actual policy. But more importantly, based on the opinion of our experts, Chicago Title Agency and Chicago Title Insurance Company are one and the same in practicality. Our interactions and the procurement of both the title commitment and then ultimately the title policy was through Chicago Title Agency and its employees. Those two worked hand in hand and were ultimately equally responsible for the creation and execution of what ultimately turned out to be the title policy. We could appreciate where the trial court came from, that the insurance company is CTIC. But in light of the underlying facts and how the title commitment, title search, and ultimately the title policy all came to fruition, involved both entities, and we believe both entities have some responsibility, particularly in light of our experts' opinion of the interagency relationship between the two.
Thank you.
Could I ask another? I hate to take up time that you want to reserve for rebuttal, but what happened? What changed with the city of Mesa that initially allowed the sale of individual parcels, and then when Horton wanted to purchase it, it said, no, you can't do that? What was this? Did the city explain what the difference was?
It's a great question. And ultimately what happened is D.R. Horton. We had talked to the city before we purchased the property, told them our intended use. They agreed and said that's permissible. We procure 19 building permits and build 19 units. And then ultimately when D.R. Horton comes back and tells us that DHI has discovered a defect with the plat, we disagreed or didn't know if we believed D.R. Horton. We thought, well, the city's been issuing us building permits. Let's go back to the city and they'll keep issuing us building permits and they'll tell D.R. Horton they're wrong. And then we can sell and finish up this deal. We take it back to the city, then take a better look at it and look at D.R. Horton's rationale and analysis and ultimately agree with DHI and D.R. Horton. So it was the D.R. Horton DHI title search that ultimately persuaded the city that we needed to go back and replat the property. But for D.R. Horton, we may have got 50 units in before this thing was discovered. But because D.R. Horton came in and DHI did according to our expert, a valid title search, it was discovered and the city agreed with it.
Thank you, counsel. Do you want to reserve the remainder of your time?
Well, I can see is that 158 left my 20 minutes?
Yes.
That's my 20.
Yes.
Then I will reserve the remainder of the 158.
Thank you. Mr. Workin.
Thank you, Your Honor. Good morning. May it please the court. My name is Charles Workin. I represent the appellees, Chicago Title Insurance Company and Chicago Title Agency. I submit to you that there is a lot to unpack in this case, and therefore, with your indulgence, I would like to request a few minutes to suggest an outline to simplify the resolution of this case. And as I do so, I ask that you keep in mind that title insurance indemnifies the purchaser for defects in title that cause a loss or damage. So, with that said, the broad questions to be answered in this case are whether, first, under the literal terms of the policy, is there a defect in title that caused damages? And is there coverage for that? Is coverage for any such defect excluded or accepted? And beyond the literal terms of the policy, was there conduct by Chicago Title that created a reasonable expectation that some policy term provided coverage, or that an exclusion or exception does not apply? The broad answers to those questions in this case are that there is no applicable covered risk. VACC's title was vested as it is stated in the policy. They got a fee simple interest in the designated units and tracks. The plat was properly created. Title was marketable just as it was purchased. It could have been resold in the same way, shape, and form. And access was admitted below in the trial court. Or if there's still an access problem, it was cured by the later quitclaim deed that my opponent made mention of. The endorsement.
Why isn't that what is your position on the fact that the original seller had to issue a quitclaim deed to clean up any question as to whether the entire property had been conveyed?
I think it was acknowledged in the opening argument that it was the intention of the seller and VACC to sell and purchase the entirety of this project. And if there was something overlooked, something omitted from the description that they put in their purchase agreement and that they gave to Chicago Title to insure, and that was then carried forward into the deed to VACC and was in fact insured, if there was something omitted in that, or if there was some gap or gore or separation, it was cured by the quitclaim deed, and therefore under the policy, there was no defect in title, and there is no.
Let's say there's no quitclaim deed. Would you, if the original seller had said, no, we're not going to, we're done. We sold you what we sold you. Would you agree that there's a claim under the policy that there was a problem that portions were not conveyed? Why isn't it covered to at least the cost of getting that aspect of the policy cleared up?
I would not agree that that was covered under the policy. And under the policy, there is an exclusion in 3C for any defect in title that does not result in loss or damage. And if there was some omission, we insured what we were asked to insure. And we are only insuring whether there is a defect in that title to those tracks and units, not title to something else that was omitted by the seller and buyer. So the endorsements do not provide coverage either. If I may continue my outline, VACC admitted that the title that was conveyed to them is the same as is on the plat, and the subdivision was also properly, I'm not saying that they admitted this, but it is a fact, it is a legal fact that the subdivision was properly created for leasing. It was approved by the city of Mesa some years before. And there's also no coverage for under the continuity endorsement because the lots, the units are in fact contiguous, but if they are not, any lack of contiguity was cured by the subsequent quitclaim deed. And finally, the coverage is excluded not only by 3C, as I mentioned, but by also 1A, because the reason they had to replat this project was solely because they had changed the use of it, and the plat as it was originally approved was only suitable for leasing, not for sales of individual units in fee, because there were no dimensions for the individual units. And lastly, there is no reasonable expectation of coverage here. The title policy was negotiated, but even if we put that aside, VACC's statements to Chicago Title of what it intended to do with the property later, that is to sell the units in fee simple, does not give rise to a reasonable expectation of coverage, because that expectation would have to be anchored in some provision in the policy that gave the appearance of coverage. And there's no such provision that has been specified by VACC.
But the remove lease provisions, that doesn't get them there?
Your Honor, the lease reference to the ground lease is a red herring. If you take a look at the commitment for, which is, I believe, Exhibit 8 to the plaintiff's statement of facts, the two ground leases that are referred to in the Schedule B exceptions are ground leases that cover only a few of the units, not the entire property, not all of the units that were being sold. So it's not as though this entire project was subject to a ground lease. It wasn't. For some reason, a few units, I didn't calculate the number, it looks like 6 and maybe another 10, perhaps 16 of the 369 units being sold were subject to a ground lease. And what was negotiated was the removal of that restriction by, undoubtedly, the termination of those ground leases between the parties to them. So that is my outline, Your Honor, for the resolution simplification of and the resolution of this case. I can go through the individual covered risk as you wish, but I'd like to focus on the covered risk of unmarketable title. And the definition of unmarketable title is found in the policy, so we need not refer to other authorities such as the Sabin case. And unmarketability is a question of law, not one of fact, and therefore the opinion, the affidavit of plaintiff's expert, Mr. Caldwell, considered. The claim here of unmarketability is based on the plat, and the plat excludes coverage for even covered risk if one of the restrictions, or I should say exclusions, of the policy applies. Actually, B6 is in the restrictions. B6 accepts from coverage any restrictions shown on the plat. This plat, as it was originally platted before it was amended, describes these units just by number without any individual dimensions for each of those units. And by law, the units could not be sold in fee simple to anyone without the ability to describe each of them by dimensions of feet and angles or what have you. So the plat, by its own design, is restrictive. It restricts the use of the property to a leasing of the units, not to a sale in fee simple. Therefore, given that restriction B6, you cannot make a claim for unmarketability based upon the plat, which is what plaintiff has tried to do. And VACC doesn't dispute that the only reason that this plat had to be replatted was because it desired to change the use of the property from leasing to sales. And the fact that, and it's a disputed fact, but we assume it to be true for our purposes today, that VACC told the city and told Chicago Title that it intended to sell these units in fee simple. Those statements are immaterial because for all Chicago Title could know, VACC intended after closing the sale to go out and have the project replatted.
But so you're suggesting that this is no different than if there's some sort of zoning restriction on the property that exists at the time of the purchase, the title company does not ensure some other use of the property inconsistent with the zoning restriction?
I think that's a fair comparison, Your Honor. If the property was zoned for one use and they bought it with that zoning in place, intending to put it to another use that required different zoning, that wouldn't give rise to a defect in title and a claim on the policy. Likewise here, the property by its own design, by virtue of what the plat does not include, which are dimensions for individual lots, and given the subdivision ordinance in Mesa and state subdivision statute, the lots need to be described by meets and bounds, and they were not. And in order to change then from a lease to sale, the property had to be replatted. And
what if it's not clear what the zoning, sorry to interrupt, what if it's not clear what the zoning restriction is and everyone assumes that zoning on the property allows the construction of residential homes, and then they subsequently determine that there is a zoning restriction on the property that's different than what everyone contemplated at the time of purchase. Would that be covered under the policy?
No, it would not, because the policy is subject to that zoning, whatever it is. And what somebody thought it was mistakenly doesn't give rise to a claim because that there's a defect only in the buyer's understanding or belief. The property is what it is. And
could you negotiate a provision to that effect that says this property may be zoned? Is that something that's ever negotiated as part of a title, acquiring a title policy?
Your Honor, I don't know the answer to that question. But the policy excludes from coverage in 1A any law regarding the use of the land or the subdivision of the land or the effect of any violation of such laws. So, here we have a situation where the sale of these lots in fee simple without replatting was a violation of law, and the policy simply excludes coverage for the need to replat because as I've said, the plat, it was obvious on its face that it only lent itself to leasing. And I was about to say a moment ago that a lot of us think of subdivisions as being a property that's divided into parcels to be sold in fee simple. The definition of a subdivision also includes the division of property for leasing. And although I don't think that's a citation contained in my brief, I would refer the court to Title IX of ARS, which is escaping me at the moment. With your indulgence. 9-46302 defines a subdivision, and it includes a subdivision of property for sale or lease. So there simply is no covered risk here that covers the situation of a plat that is suitable for one use and but not suitable for a use to which the buyer wants to change it. And the endorsements do not provide coverage. As I said, the property was in fact the same. The property conveyed was the same as that shown on the plat. And I've already spoken to contiguity, and the coverage is excluded, as I've said, by exclusions 1A and 3C, and coverage is accepted by B6.
Counsel, in your view, what should VACC have done to prevent what they say has happened here? If they knew that, if they told you that they wanted to sell this in fee simple, they knew that it was land lease right now, they knew that they may have to replat, is there anything that they could have done differently that would have protected them from any potential future damages for having to replat, as far as title insurance is concerned?
I'm not sure that there's an answer to that question, Your Honor, except that they could have changed what they were buying. And if they had let me answer it this way. They could have bought it as is and then turned around and replatted it, which was, undeniably necessary because of the change in use. And then they could have come back to Chicago Title or any other title company to insure that plat and the title to that property.
So they in theory could have requested from the seller initially that it be replatted before they purchased it. Then it would be covered under the title policy. Is that what you're saying?
Well, then yes, that would be the other alternative, if they could have contracted to buy something different. And let's keep in mind here that the title insurance that was purchased is to protect against defects in the title that VACC purchased, not in the title that it later wanted to sell to others. And even after closing this deal with this plat and this policy, they could have come back and gotten a different title policy covering a replatted property and the individual units for the purpose of fee simple sale. But they owned the fee simple interest in each and every one of these units from the time of closing forward. That has never changed. And by the way, I think in answer to Judge Catani's perhaps final question of my opponent, what changed with the city of Mesa? Well, nothing really changed, except it came to the city's attention that units had been sold in fee simple after VACC purchased. That wasn't done with the city's permission. You wouldn't need the city's permission. For all the city knew, leasing was still going on, but VACC went out and sold some units in fee simple and then contracted with Horton to sell the remaining units as subdivided single-family home lots, which is something different than what they bought. And then Horton's title investigation revealed that the plat did not lend itself to that, which caused everybody to go back to the city and say, what the heck? And the city, that's when the city responds with its letter in the record saying that your plat is not compliant. I see that my time has expired, but I'll answer any further questions.
Thank you, Mr. Working. We appreciate your argument. Mr. Broadbent, we'll give you 2 minutes for rebuttal. Mr. Broadbent?
He's muted, it looks like.
I apologize. I got a couple minutes into a great argument, and then I realized I was on mute.
That's quite all right.
Okay. Just to, I guess, repeat myself. I think opposing counsel raised a couple good questions or made a couple of statements I think highlight the issues in this case. He said it was open and obvious on its face that the plat had to be amended, or that it was undeniably necessary that the plat had to be amended. In fact, it wasn't undeniable, or it wasn't obvious. In fact, we sold 19 units and that were insured by 2 other title companies. In fee simple, not as a leased product, but in fee simple, doing exactly what we told appellees we were going to do. If it was so obvious, if it was so clear on the plat that it couldn't be done, in fact, those title insurance companies would never have insured that title. They insured the title because, in fact, it wasn't obvious. Appellees that are expecting my client, VACC, to essentially be title experts. That's what we hired them for. If ultimately this plat was so restrictive, we couldn't do what we were telling them we were going to do, that's what we hired them for. But it wasn't obvious and it wasn't undeniably necessary. Otherwise, we would not have been able to sell those units. Opposing counsel talked a bit about subdivision, and the subdivision needs to be defined by meets and bounds. I would submit again, we bought a subdivision endorsement to make sure we could do exactly what it was we said we were going to do. He spoke about buyers' understanding of the effect of the policy. That goes again to our reasonable expectations doctrine and that reasonable expectations
Judge
argument.
Howe, I'm sorry to interrupt. I got kicked off and then I jumped back on, but I'm not seeing Judge Catani.
Yes, I've been looking for him too.
So I wonder, I mean, I hadn't touched anything and it kicked me off. So I can go back and watch something, but if we don't have Judge Catani too, maybe.
Yes, can we pause for just a moment? We apologize.
That's okay.
Well, I found Judge Catani and asked him to join, but
Okay.
my computer says he is calling.
Judge Howe, one moment. We're getting Judge Catani set up with a separate tablet.
Sure.
He also got kicked off as Judge Bailey did.
It's my judicial assistant that made her she got kicked off.
Sorry about that. Don't know what happened.
I got kicked off too, so you're good.
You can hear me now?
We apologize, Mr. Broadbent. Why don't you start from the top?
Okay.
Well,
hopefully it'll be smoother the third time around, right? So just real briefly, I say opposing counsel talked about that that it was open and obvious on its face, on the face of the plat, that it had to be amended, or that it was undeniably necessary. And the argument that I made just briefly ago was that if it was so open and obvious, how were we permitted to sell 19 units that were insured by 2 separate title companies in fee simple, not as a lease product, not as opposing counsel asserts the subdivision was designed, but as a fee simple product? Again, appellees are asking my client to be title experts. And frankly, that's what we hired them for, was to be title experts.
Can I ask you, when you say that you knew that the land leases had to be removed upon closing, what did that mean someone had to do? And whose fault was it that that didn't happen?
Great question, Your Honor. Ultimately, they had to be extinguished. They had to be extinguished by agreement from the seller, and that was what we contracted with appellees to do. Chicago Title Agency, and then ultimately Chicago Title Insurance Company, was supposed to extinguish those at closing and have documents from seller to extinguish those. And ultimately it didn't happen. We didn't find that out until after the fact. Then just real quickly, as I see my time is running down, a couple things. Appellees continue to rely on this idea of a changed use. Again, we've never changed the use. We've expressed our intent to use the property for this purpose from the beginning. It was the reason why we bought these subdivisions.
You agree that it's a changed use from what's contemplated under the plat, right?
I disagree that, no, actually, I don't agree. The way the plat was designed, as explained to us by the seller, and as confirmed by appellees, was that with the extinguishment of those ground leases, it would convert into a fee simple product. If we had thought that the plat was going to remain as is and we were going to be stuck with these leases, we never would have closed. But ultimately, we were told by both seller and by the agency that ultimately with the extinguishment of those ground leases, it would be a fee simple product. And I guess just in conclusion with my time, opposing counsel said, we insured what we were asked to insure. And that is in fact the key issue. We bought what we thought we were buying and thought it covered claims exactly like this. And ultimately my client's been damaged and looks to appellees for recovery. Thank you.
Thank you very much. We apologize for the technical glitches. We appreciate your arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned. Thank you.
Thank you, Your Honor.
Thank you, Your Honors.